Today I would like to address on three important judgments of the Honorable Supreme Court of India. These judgments are related with the criminal law and very much important. These are not important only from the point of litigants but also from the viewpoint of lawyers who are practicing in the criminal sites. Number one judgment is LALEETA KUMARI versus State of Uttar Pradesh. As we know that a criminal law can be put into motion by registration of FIR. According to section 154 of the Criminal Procedure Code, once the information is given by the informant and the information reveals that the cognizable offence has been committed by known or unknown person, in that case, the in charge of the police station is under obligation to register FIR. Therefore, the officer or in charge of the police station does not have any discretionary power. He cannot refuse to register FIR, and his powers are not his powers in discretionary way or arbitrary or whimsical way. He has no way except to register FIR because the duty casted on the police officer is of mandatory in nature, statutory in nature. Therefore, the criteria is that once the information given by the informant orally or in the written form against known or unknown person that someone has committed cognizable offence, then after examination of such information, it reveals prima facie to the in charge of the police station that cognizable offence has been committed out. In that case, the in charge of the police station has to register FIR, and there is no other way left available to him. Therefore, the duty casted on the police officer is of statutory nature, mandatory in nature, and he has not got the discretionary power. The criteria to check whether the information given by the informant to register FIR reveals cognizable offence committed out or not. Therefore, we know in practical life that if a poor person goes to register FIR against a builder or politician or rich person, etc., in that case, police officer will not register FIR and he will give the evasive answers. Come tomorrow, day after tomorrow, or he say that he will be doing inquiry, or he is doing inquiry in the matter, etc. And therefore he will give number of reasons and will not register FIR. These things goes on, and the aggrieved person has also right to move to the honorable courts. Also, he can file a private complaint. He can also go to Honorable High Court to file a writ petition, etc. But because of such a problem, because of such a dereliction in the duties, the Honorable Supreme Court of India has passed a judgment in LALEETA KUMARI versus State of Uttar Pradesh. This judgment is casting duty not only on the police officer but the others also, and the all police officers also, higher authorities also. In this judgment, the Honorable Supreme Court said that once the information given by the informant, either in the written form or oral form, to register FIR, then if such information reveals the cognizable offence has been committed out, then the officer cannot deny to register FIR, and there is no discretion left with him, and it is his statutory duty. He is bound by his duty to register FIR. There is no other way left to him. There are no discretionary powers vested with him, but he has to register FIR. This is stated in the LALEETA KUMARI versus State of Bihar. And if at all the police officer takes time or consume times under the name that he is doing a preliminary inquiry, then such a preliminary inquiry has to be concluded within the span of 7 days. This has been specifically said by the Honorable Supreme Court that such a preliminary inquiry has to be conducted within the span of 7 days, and on what subject such a preliminary inquiry can be conducted by the police officer. Not regarding all the crimes, but only certain offences are there in respect of which the police officer can do a preliminary inquiry. He can seek some time, and his seeking time will be justifiable. However, those subjects and crime related are matrimonial offences between the husband and the wives, or the offences related to money, or that is economic offenses, or offenses are against the public servant. In that case, to register FIR, police can take some time under the name of preliminary inquiry. Therefore, this can be justified, and however, Honorable Supreme Court said that such a preliminary inquiry has to be concluded within the time or span time of 7 days only. But the scope of this preliminary inquiry is limited only to know or ascertain fact whether the information provided by the informant reveals cognizable offense has been committed or not. Therefore, the officer cannot go into the veracity of the offense, credibility of the offenses, genuineness of the offenses. Therefore, he should not bother about the credibility, veracity and genuineness of the offenses. Only he has to check. His way is only limited. He has to check. His scope is very limited. He has to check only from the information so given to him whether it reveals that cognizable offense has been committed or not. If offense is committed, if cognizable offense is committed, then he has to register a FIR. If non-cognizable offenses are registered, offenses are committed, then he can register NC only. But he cannot consume time. However, he cannot go into the credibility, genuineness, veracity of the offense. That has been specifically laid down by the Honorable Supreme Court in this judgment. And if such an officer does not register FIR, then against such a hearing officer, against such a police officer, disciplinary action can be taken, and contempt of court, action under contempt of court can also be invoked against such a police officers. And in disciplinary actions, the particular department may suspend him, may dismiss such an employee for non-followance of the guidelines of the Honorable Supreme Court. Therefore, punishment is also provided against the erring officer under the law of contempt of court, and disciplinary action can also be taken against such a police officer. The very purpose of this judgment of LALEETA Kumar is that the police should not harass the common man or poor people. If they are aggrieved person, they have come to the police station to register FIR, then their information need to be checked, and the police officer is under obligation to find out whether cognizable offense has been committed or not. If yes, then he has to register FIR. Therefore, it is not depending upon the will or wish or whim of the police officer to register FIR, but it is statutory duty casted upon him, mandatory duty casted upon him, which he cannot deny or he cannot shirk. If he shirk, then under contempt of court and other proceedings can be initiated against such officer, erring officer. This is the crux of this LALEETA Kumari versus State of Uttar Pradesh. Therefore, it is the duty of the all police officers to follow these guidelines given by the Honorable Supreme Court in LALEETA Kumari versus State of Uttar Pradesh. Now, another judgment which I would like to discuss with you here is related to arrest and power of arrest, that is ARNESH Kumar versus State of Bihar. Earlier judgment of LALEETA Kumari versus State of UP is related to FIR, registration of FIR, that is mandatory duty. And now the ARNESH Kumar versus State of Bihar is related to the right of arrest or power of the arrest of the police officer. What laws of arrest, that is CRPC, says that police officer is empowered to arrest a accused of who has alleged to have committed offense of cognizable in nature. Because under CRPC, law says that if offense is committed, cognizable offense is committed, then police can arrest without warrant and can do the investigation or can start the investigation without the permission of magistrate. Therefore, cognizable offenses are such offenses in which the police officer can arrest without warrant and can start the investigation without the permission of the magistrate. Therefore, ample powers are given to the police officer. Therefore, there are chances that they will abuse or misuse the powers, and this was happening also in number of the times in past. Many police officers have misused the provision of power to arrest, because CRPC says that if the offense is cognizable, then police officer can arrest without warrant. Then question of law, of pure law arises, whether offense is cognizable, does it mean that in all the cases, police officer has to arrest blindly? No, because though the law is allowed to him to arrest the accused of having committed cognizable offense or alleged to have committed cognizable offense, however, it does not mean that he should be arrested. Registration of FIR, though FIR can be registered against such accused, but it doesn't mean that the police officer has to arrest that person. The Honorable Supreme Court in many of the judgments have laid down that the liberty of a person is of utmost value, and which is enshrined in Article 21 of the Constitution of India. Therefore, the personal liberty is of utmost value, which should be protected. Liberty of individual should be protected, and the fact that a person has committed cognizable offenses doesn't mean that he should get arrested, because this conduct of the police officer is not only ruins it not only ruins the reputation of the person who gets arrested, but the reputation of his family also gets damaged or comes at a stake. Therefore, humiliation will be caused if person get arrested, because most of the time police in normal cases they bring with a police van and they tie the hands of the accused and they drag him away, etc. And therefore, they violate number of judgment of the Honorable Supreme Court, that there is already a judgment of Honorable Supreme Court, I think Basu, and thereafter this judgment of ARNESH Kumar came into picture in 2014. Now, what guidelines have been framed by this Honorable Court in this judgment? That power to arrest is one thing, power of the police is to arrest accused is one thing, and justification of arrest is another thing. Therefore, the fact that a person has committed cognizable offense, it doesn't mean that police should not apply their mind or should not apply their mind. Police always have to apply their mind, and police should not work in mechanical way like a machine, etc. Therefore, they should think whether arrest is really required or not, because sometime what happens, the accused is likely to run away out of the country. In that case, his arrest is justifiable. Accused is likely to dispose of the property, then in that case his arrest is justifiable. Accused is likely to commit another offenses, in that case his arrest is justifiable. Therefore, he should justify his conduct of arrest. The thing that only CRPC has given power to him and the accused has committed cognizable offense, it doesn't mean that blindly or without applying his mind the police officer has to arrest. No, noble. Therefore, this is the thing laid down by the Supreme Court in ARNESH Kumar versus State of Bihar. Therefore, justification of arrest should be done, though the powers of arrest have been given to the police officer. Second, the notice under section 41A has to be issued by the police officer to call that accused in the police station. If such a notice is issued, then the person to whom it is issued, accused, has to remain present in the police station to give the answer, to record his statement, etc. If he may remain present or he may not remain present, that is up to him. However, even if he remains present, then police officer may arrest him, recording the reasons, justifying his act, and once he gets arrested, then the other provisions of law come into picture, that within the span of 24 hours, the accused has to be produced before the nearest magistrate, and the accused cannot be kept in a lodge, etc. for 2 days or 3 days, which normally police do. Therefore, the accused has to be produced within the span of 24 hours before the nearest magistrate, and while counting such a time, the journey time should be excluded. Thereafter, the duty is casted on the judge to check whether his detention should be extended by order. Therefore, he should state the reasons as to why his detention is required, or police should also cite the reasons before the court that his custodial interrogation is required. Why such a custodial interrogation is required? And this judgment of ARNESH Kumar is not only applicable in case of 498A cases or dowry prohibition cases, but it is applicable in all the cases, criminal cases, criminal offences which are punishable up to 7 years. Therefore, this is also one of the important things which I would like to bring before you and clarify this, that most of the people, they think that the ARNESH Kumar judgment versus Arnesh Kumar versus State of Bihar, this judgment is applicable only in respect of 498 matters or in respect of Dowry Prohibition Act. No, it is applicable to all the offences which are punishable up to 7 years. It means if the offence is punishable for more than 7 years, like murder, rape, or forgery under section 467 CRPC, in that case, the police can arrest and the judgment of Arnesh Kumar will not be applicable at all, because the offences are punishable for more than 7 years. Hence, this judgment, Honorable Supreme Court of India has directed all the secretaries of the state and Director General of the state to notify this judgment, so that the all police stations can implement this judgment. All police officers can implement this judgment of Arnesh Kumar versus State of Bihar. And the duty is not only casted upon the police officer but also upon the judges to ensure that the further custodial grant of custody is justifiable or not, whether really required or not. And in case of violation of the judgment, the hearing officer can be punished and disciplinary action can be taken against such a police officer and the judges also. And this will be under contempt of law also. Apart from the disciplinary action, law of contempt of court can also be invoked against such a police officer as well as the judges who do not follow this judgment of Arnesh Kumar. And in this judgment, the Honorable Supreme Court has found that 85% of the cases under 498A and Dowry Prohibition Act are false, and therefore conviction rate is only 15%. In only 15% cases, the conviction is granted, and remaining 85% cases, acquittal have been, there was acquittal of the accused. It means the chances of filing fake or frivolous cases cannot be denied. Hence, because people think that only if they have registered FIR, then the person will get arrested and they will feel happy. Due to some political rivalry or due to some matrimonial disputes, they feel like that is a human tendency. However, the power of the police should not be misused. Police officers should always apply their mind and should follow this judgment of Arnesh Kumar versus State of Bihar. Most of the time in seeking anticipatory bail application, this is argued by the lawyers that when the offence which has alleged to have been committed, if such an offence is punishable up to 7 years only, then the judgment of Arnesh Kumar versus State of Bihar is cited out by the lawyers, saying that the accused or applicant must be protected as per the guidelines stated in the Arnesh Kumar versus State of Bihar. As the offences are not punishable for more than 7 years, therefore his liberty should be protected. And this is a reasonable argument which can be considered by the court, Sessions Court or Honorable High Court, while hearing the anticipatory bail application. However, this judgment of Arnesh Kumar is not applicable when the offences are punishable. Offence which have been committed or alleged to have been committed are punished for more than 7 years. Now, one more judgment which I would like to mention here, which is very much important, Priyanka SRIVASTAV versus State of UP. In this case, the Honorable Supreme Court has said that the guidelines or the compliance under section 154 subsection 3 of CRPC need to be followed. Because why? To register FIR, to invoke the criminal law, to file the FIR, aggrieved person will go, complainant will go, informant will go to the police station, he will complain to concerned in charge of the police station. Then there are two possibilities: either he will register FIR or he will refuse to register FIR. Now, second possibility, that if he refuses to register FIR, then the copy of complaint should be given either by post or by hand delivery to the superintendent of police or commissioner or DCP. And then if DCP or police superintendent of police has also not directed to register FIR to concerned inspector, then the way available to the aggrieved person or complainant is to file private complaint under section 156 subsection 3 of CRPC before the JMFC court, magistrate court, and he can file a private complaint. Therefore, when the case under section 156 subsection 3 is filed before the magistrate, he will think whether the provision under section 154 subsection 3 of CRPC have been complied with or not. If it is complied, then he will hear the matter. Otherwise, he will say that to comply the same, because it is laid down by the Honorable Supreme Court in PRIYANKA SRIVASTAV versus State of UP case laws. However, prior to that, there was a judgment of Honorable High Court of Bombay in Popat Bhai versus Panchavai, wherein the Honorable High Court of Bombay has said that even if there are no compliance done by the petitioner who files complaint under section 156 subsection 3, then still a magistrate can hear without such a compliance, without such a compliance under section 154 subsection 3, magistrate can hear the petition, can proceed with his private complaint. However, now as on today, there is a judgment of Honorable Supreme Court of PRIYANKA SRIVASTAV versus State of Uttar Pradesh that is going against the judgment of Honorable High Court. Therefore, obviously, the judgment of Supreme Court need to be followed. Hence, the rule is that the compliance under section 154 subsection 3 of CRPC has to be done, and the complainant who wants to file private complaint to register FIR should go or approach the inspector. Thereafter, if he denies, then to the SP. Thereafter, he should file the private complaint. That will be checked by the magistrate while hearing the petition under section 154 subsection 3 of CRPC. However, to advance the justice, from the viewpoint of advancing the justice, if judge feels that it will be wrong exercise and wastage of the time, and he will, because if these conditions have not been complied, then that complainant has to withdraw the application or complaint filed before the magistrate. Then he has to comply all these things, etc. Therefore, it seems something wrong in that case. To advance the speedy justice, judge may in his discretion can waive such and can hear or entertain petition under section 156 subsection 3, that is popularly known as a private complaint. So here today I have covered 3 major judgments of the criminal side: LALEETA KUMARI versus State of Uttar Pradesh, PRIYANKA SRIVASTAV versus State of Uttar Pradesh, and ARNESH Kumar versus State of Bihar. Thanks for hearing to me.